Welcome everyone for another sort of CIPIL IP talk. We are very lucky to have Dev Gangjee coming to give us a talk here. Dev has been at the LSE for quite some time and has been in Oxford since about the time when I started here, probably, right? 2.5 years, 3 years now, roughly. Dev is an expert on trademarks, GIs, IP and development issues, and so on and so forth. And he's here to talk about shape exclusions, an aspect of which is wrong talk. Yeah, no worries. Sorry to. I think it's sort of a little one floor up and then to the. Anyways, so Dev is here to talk about shape exclusions. Well, that is, I told all my students, please come here because it's so relevant for all your exams and for the rest of your life anyways. One thing which I liked about the sort of abstract you sent around is the fact that it also pointed to one of the things I always sort of highlight in the supervisions on the absolute grounds dealing with shapes, and that is the idea that the sign must consist exclusively of a shape which then sort of meets these particular exclusion grounds. So we know a little bit about that from, I think, Lego, right? However, there's some uncertainty. Dev is going to solve all of this and solve all other outstanding issues on shapes, and so I'll leave it to him to say the rest. Thank you.
Thank you, Henry. Thank you. Thank you for inviting me. It's very good to be here. I don't come here often enough because of the ridiculous transport arrangements between Oxford and Cambridge, so it's very good to be here. The people, and I also realize how pressed you are for time, so I'm going to try and make this as useful an opportunity as possible. The alternative title was Stumbling Blocks because of the Lego bricks, so I'm saving that up maybe for another occasion, but I thought I'd take a close look at functionality. I've been dipping in and out of this topic now for about 3 years, toying with the idea of writing something on it. And it's always so individual case, the developments are so case specific that it was helpful to step back and take a look. Now that we have something under each of the three limbs, it's a good time to be looking at this because you can see how the individual tracks are developing and maybe some of the big picture issues emerging as well. So this is some of the, this is the coverage for the evening. I'm going to start off with the law, the underlying policy, and some of the meta decisions which have come up in terms of how the provision as a whole is to be structured and understood. I'm then going to talk about the gateway Henning mentioned, the exclusively requirement, the essential characteristics gateway into the provision. Then each of the three kinds of shapes which are excluded, not only the core prohibition itself and what it means, but also some of the recent developments in the case law. So very recent cases over the past 2 years have been doing some interesting things to add layers of detail to these requirements. And I was going to end ambitiously with a few open questions, but I had only time to pick one. It's an interesting question, and I'm hoping it'll generate further conversation. By my standards, it's a boringly technical, very textual talk. There's going to be relatively few bells and whistles, lots of analysis. It's a helpful for the exams kind of talk, if I can characterize it that way, or just for sort of thinking closely about the issues. So here's the prohibition. It's contained in Article 3.1e of the Trademark Directive. It mirrors Article 7.1e of the Community Trademark Regulation. All of this is going to change in the near future, but this is the core on this side, and that's what it's going to change to. The following shall not be registered or be declared invalid if they are registered signs which consist exclusively of, and that's the gateway in, shapes which result from the nature of the goods themselves, the shape of goods which is necessary to obtain a technical result, or a shape which gives substantial value to the goods. The new developments basically are about the addition of shape or another characteristic. So it's opening up new territory. It might be a color. It might be the kind of subject matter which was litigated in Dyson, where they had to handle the problem under a sign. If you run the Louboutin red sole shoe cases now under this provision, you might be able to capture some of the concerns there under any other characteristic. So it's one of the topics I was hoping to cover towards the end. I haven't formally put it down here, but I'm happy to come back to a discussion of what that means. In terms of the underlying policy, it's gradually clarified across Philips, Lego, and then Hawk. The underlying policy is about preserving free competition in a nutshell, and that's what the Philips case tells us. We all know what Philips applied for, that as their trademark up there, which was construed by the court to depict a three-dimensional sign application, and that mapped onto the heads of their three-headed rotary shavers, which they were actually using. That's the goods they were using the signs on. And so the question was, is it hit by any of the exclusions? And the UK courts explored all of the exclusions before sending the technical result exclusion up to the Court of Justice for an interpretation. And as part of that interpretation, to see whether that application is hit by the technical result objection, the court gave us the basis for these provisions. It was talking about the technical result one specifically, but it spoke about it in the language of preventing a monopoly on technical solutions or functional characteristics, which a user is likely to seek in the products of competitors. So it's trying to prevent trademark law forming an obstacle to competition law, and that's really the heart of it. Preserve competition and ensure such shapes may be freely used by all. That policy starts getting more finely grained. So it's a generally pro-competitive policy, but it starts relating that broad policy to the specific rationale behind these exclusions. The Lego case emphasizes that registering such shapes would upset the balance between IP regimes which have finite protection. So it's talking about looking at these prohibitions in trademark law against the context of other IP rights in the EU, and really the idea here is the other IP rights are finite, trademark law is potentially infinite. Bonus points, anyone know which is the first trademark to be registered in the UK? It is Bass for beer, and it's still going strong. So that was 1875, and it's still going strong. So trademarks continually get rebooted if you start every 10 years, and if you start doing that for shapes, you just bypass the finite time limits of all of the other IP rights. And so that's the concern there. And it's just stated more explicitly in the recent Hawke case. And I recommend the Advocate General's extensive review of the underlying policy in paragraphs 26 to 40, where the Advocate General and then the court, they interpret the prohibitions based on the underlying public interest. That's what you do with all the prohibitions, whether it's descriptive use or sort of commonly used signs. You drill down to the underlying public interest. And here the general aim is to preserve free competition, and the specific aims of indents 2 and 3 are to prevent the life extension of other IP rights, where potentially there's an IP right overlap. The reason why I've underlined potential is because they're not asking the question, is this the subject matter of a design right, a registered design, or is this already registered as a patent? They're asking the potential question, is this the kind of thing which could be protected as a patent, or the kind of thing which could be protected as a design, which is a tricky sort of analysis. You're creating a counterfactual world, and you're saying, is this design law type subject matter in a fairly loose way? You're not making it jump through design law hoops or patent hoops. You're asking it at quite a fuzzy level. And so that potential for overlap is what's driving the prohibition. So that's the general aim, and the specific aim is to prevent the exclusive and permanent right which a trademark confers if the aim is to extend the life of other IP rights. In terms of the scope of the provision, we have some interesting developments. Perhaps the first one to speak about is 2D shapes can count as 3D shapes for the purposes of this provision. And that's an interesting new development in Yoshida Metals. So that is the application the applicant submitted on the top right-hand corner. They just submitted a picture without stating what that picture was supposed to represent, and the classes of goods and services included cutlery and knives in particular. They didn't say it was the handle of a knife. So their argument was, it's a picture, it's a figurative mark. Don't treat it like a shape, don't run it through the exclusions. It doesn't deserve to go down that channel. And the court said, well, you can have 2D shapes. You can have a 2D star, 2D circle, 2D rectangle. So if 2D shapes are shapes, then we can run them through the shapes analysis anyway, essentially. So the provision doesn't define which marks are shapes, and therefore it encompasses straight up three-dimensional shapes, but also 2D representations of 3D shapes. And so it tries to capture the tactical game playing by applicants who might choose to play the it's a picture, not a shape kind of argument that seeks to draw it within the policy objections. It's also been repeatedly emphasized that the shape objections aren't directly related to the broad trajectory of trademark law, which is about consumer perception and distinctiveness. It's got nothing to do with distinctiveness because the policy objections trump, and therefore consumer perceptions, where they count, are only one factor For example, when you're trying to determine the essential characteristics of a shape, and we'll come to that quite soon. It's also quite clear that acquired distinctiveness cannot save a shape which is otherwise prohibited. So the policy objections are really not like the rest of much of trademark law. It's not about distinctiveness, it's not about consumer perceptions. You're thinking with a different framework in mind. And one of the other interesting early questions is, there is no cumulative stacking of ingredients. One of the interesting early conclusions by the court, and I suspect some people in the room, including people sitting in the back, might have a different sort of opinion on this. I think I might agree with the court actually on this one. But I think there may be a way that there's enough space to play games so you can go after the bits that you're interested in keeping out anyway, potentially, and we can have a chat. We can have a chat about that later. What are they basically saying here? You can't take two bits of the shape which are designy type bits, aesthetic pretty bits, and one bit which is technical, and smoosh them together and say, together, these are the three most important bits of the shape. Each of them triggers a policy objection. Cumulatively, you mix and match and get policy objections. If you go back to the policy basis which I spoke about before, then mixing and matching makes sense. If the policy is to keep stuff open, then you should be allowed to mix and match and keep shapes out. But the problem with this is then the entire structure of the provision becomes less relevant. Why set things up in terms of overall shapes when you're actually just talking about ingredients? You should be talking about the ingredients more directly. So I think it's a valid line to draw to say you can't mix and match, to cumulatively say two bits from here and one bit from there mean the total of three satisfies the prohibitions. And Hawk and KitKat sort of emphasize that. So that's by way of some of the interesting recent developments contextualizing this provision. Let's now turn to the essential characteristics gateway, which is controversial. It's difficult to understand and apply. It's easy to get a sense of why the court set this up, but then operationalizing it becomes quite difficult because it lends itself very easily to different agendas. It's fuzzy. It's fuzzy, therefore it's flexible. It's fuzzy, therefore it's got all the downsides of flexibility as well. So the way the question arose was, the gateway question arose because the provision says signs which consist exclusively of technical shapes or sort of shapes which add substantial value or result from the nature of the goods. You then only do that analysis after addressing the question of whether those are exclusively shapes which do this kind of thing. So one of the early questions, and I've put it quite crudely, but that's the core of the question, does exclusively mean 100% of the shapes satisfies the prohibition? If that was the requirement, then very few shapes would meet those, would meet that threshold condition, and the exclusion would shrink to become a very narrow exclusion. So the answer suggested by the court in Phillips, but not really developed, is it's only the essential characteristics of the shape which have to satisfy that exclusively test. So exclusively doesn't mean 100%. Exclusively means, well, the guts of the shape, the essential characteristics of the shape are technical or are a design type shape. That's the way they approach that question. And they helpfully tell us that the essential characteristics are the most important elements of the sign. Judged by what yardstick? How do you decide which elements are the most important elements of the sign? That's what Lego tells us. But then they elaborate a little further by way of the test. They do answer one question very clearly. Judged from whose perspective? Initially, in the Phillips Round 2 litigation, which considered the same faceplate, but with cute tricks being played with it now. So instead of a triangular raised faceplate area, they made it into a clover leaf, and they said that change of the outer surface of the clover leaf is just an aesthetic flourish. It's got nothing to do with a technical decision. We just think it looks nice if we do it. And therefore, that is an essential feature of the shape. That is shaped that way because it's just quirky and capricious. There's nothing technical about it. So one of the essential features is a capricious addition, and therefore we're not exclusively a shape that gets trapped by the prohibitions. For us to be trapped, all of the essential features have to be, for example, technical in this case. Here's one of the essential features. It's not technical. We're therefore saved. That argument didn't get them very far, because the threshold question was, well, from whose perspective do we judge the essential features? The answer the court came up with and applied was the consumer perspective. And it made sense because the consumer was the ultimate arbiter in trademark law. But the court rolled out a notion of a notional consumer, so a reasonable hypothetical consumer, and therefore that gave the court some flexibility to play with what she saw, what she would be willing to sort of look at. And the court said the notional consumer wouldn't notice the difference. It's a difficult. I just realized it's sort of quite silly to go all feminist when you're talking about a razor faceplate. But what the notional consumer would sort of notice is the notional consumer wouldn't notice that difference there. Lego pursued the same argument. From whose perspective do we judge essential features? We judge it from the perspective of the average consumer. Why was Lego driving this argument forward? Because what's a consumer likely to notice about their shape mark application there? What's very evident to you from their shape mark application there, which has got nothing to do with technicality at all? That's the brick they applied for up there. What's the one thing which is clearly not technical at all? I'm deliberately looking at a certain part of the room. Anybody?
The color?
Yep, thank you. The color. So great. So they deliberately submitted a red brick. Their argument was red's one of the essential features. Red's got nothing technical about it. One of the essential features is not technical. We are not exclusively a technical shape. We're home free. And so the consumer eye was the basis for this argument. It was rejected by OHIM, and Lego's one of those cases where if you trace it back all the way to the Board of Appeals, Grand Board of Appeals, and even before, it's a very rich series of decisions. You get a lot out of the reasoning. Certain arguments drop away, which are well worth revisiting. And there they said that it's clearly not the average consumer. Because of the underlying policy behind this provision, it has to be the trademark registry, which appreciates the policy and therefore takes this call about what the essential features are. And finally, the Court of Justice in Lego re-emphasizes this. It said the essential features should be properly identified by the authority deciding on the application for registration of the sign as a trademark. The trademark registry decides what the essential features are. Lego also gives us a methodology for determining the essential characteristics. It says we adopt flexibility. A case-by-case basis is the way to approach it. There is no systematic hierarchy between the elements of a sign, so there's a lot of methodological freedom. You can either go for a one-shot overall impression produced by the sign, or examine in turn each of the components. And to be fair, you can see why they've come up with such a flexible set of parameters, because it's the gateway to three very different provisions. So if you need the same test to run for an aesthetic design type shape or a technical shape, for a design type shape, overall impression might make sense. For a technical shape, you might want to break it up and analyze it in detail. So maybe that's what they had in mind when they gave the flexibility here. Overall impression or examine in turn each of the components. And depending on the degree of difficulty involved, again, sort of a very generous turning point which is handed to the decision maker, depending on the degree of difficulty involved. A simple visual analysis of the sign might work to identify the essential characteristics, or a detailed analysis based in part on criteria such as consumer surveys, so the consumer comes back in, but as one of the factors, one of the evidentiary factors, not as dispositive as the consumer would be in terms of distinctiveness. Expert opinion, so a toy industry expert speaks about the shape of a toy, for example. Data relating to prior IP rights, patents and designs come to mind, or other evidence potentially. So that's the test for determining the essential characteristics, and you have some initial channeling decisions in terms of overall or details, and once you break out into details, these are the kinds of criteria that you need to look at. The flexibility, and this is one of the sub-issues that has come up under essential characteristics, it gives people the freedom to ignore. So here's the case of Reddig. Reddig concerns the application for that knife handle. The knife handle has three components identified by OHIM and then by the General Court here as well. It's got a curved handle with a downwards angle, and you can see that bit towards the end, the upper end there, which allows someone to apply better pressure when they're using it. It's got the eye screw here, which lets the blade then become adjustable, and that's the eye screw. And it's got an intermediate section which allows you to give long cuts. It sort of allows you to hold it and give long cuts. But the applicant argued, okay, those are the individual pieces, but you put them together and you get a dolphin. And the dolphin, the way that dolphin looks, should be one of the essential characteristics of the shape as well. If you recognize it as an essential feature or an essential characteristic, it's purely aesthetic, nothing technical about it. One of the essential characteristics is not technical. The registry, the Board of Appeal, and then the General Court ignored the overall dolphin shape. This is the test they applied. Is the dolphin shape a major non-functional element, such as a decorative or imaginative element, which plays an important role in the shape? The registry said, no, it's not an essential feature, so it can be ignored. Apart from the flexibility that is given to the registry, the other thing I want to point out is they used the prior patent. This is a US patent. They used the prior patent for this particular kind of knife as the template for identifying the essential characteristics, which is sort of backward reasoning, which is the point I'm going to make next. They use the second stage to go looking for trouble in the first stage. You're first supposed to identify the essential characteristics and then ask to all of them produce a technical result. They use the prior patent, which is clearly about technical results, to identify the essential characteristics, and then they say they all produce technical results. So that's very clearly part of the problem with the test here. You're first supposed to do stage 1, then stage 2, but the stage 2 inquiry, this shape has a whiff of the technical about it. That shape has a whiff of the aesthetic about it. So therefore, I'm going to go looking for the essential characteristics, which are the technical or aesthetic. Stage 2 of the inquiry inevitably skews stage 1, because it's very difficult to identify features in the abstract. How do you come up with essential characteristics unless you have some kind of backdrop against which to do it? So you can go back looking for trouble, essentially, and that's one of the, some people would say advantages, other people would say that is one of the problems with the test. Another interesting question which has come up is when you're identifying essential characteristics, and I want to come back to this in the Rubik's Cube decision, which we look at later, do you go with the representation as submitted on the application form to the registry in terms of highlighting what the essential characteristics are? Or do you make up your own mind? And this is an OHIM Board of Appeals decision where they make up their own mind. The cancellation decision made an error because they followed the description in the trademark application. What is that? That is a motorized winch, a mechanized winch, and it's got an unusual configuration. A part of it is vertical, a part of it is horizontal. It's the sort of thing used by window cleaners when they're going up tall buildings to winch them up sort of electronically on the side. The applicant stated that the trademark relates to a motorized rope winch. The characteristic features of the rope winch include ribs on a motor housing, which are arranged vertically to the ribs on a rectangular gearbox. So the ribs and the different positioning of the ribs are the characteristic features. And the cancellation division focused on that and said, therefore, if those are the essential characteristics, then there's other non-technical stuff around and you're safe. The Board of Appeals says the cooling ribs are secondary in their functional significance with regard to the main components of motors, gears, control, and traction sheave. So using the real-world goods, a continuous cable winch, which is technical, as the template, the Board of Appeal went on to identify the essential characteristics of it. So they didn't go with the trademark application. They went with the real-world product and what it's supposed to do, perhaps by reading it through the goods and services applied for. So they went into class 7 to try and get a sense of what should be the essential characteristics of these kinds of goods and services as opposed to what they said on the piece of paper, which I think is quite interesting. The other recent development, which is also interesting, is how much do you have to do to escape exclusively? Exclusively is all the essential features, either pretty and design-like or technical and patent-like. What you need to add to it to make something a prominent enough feature to then be non-technical or non-sort of aesthetic. It's beginning to surface in some of the decisions. This is quite a low-level decision from November. It's a cancellation division decision from OHIM. Here the mark is for shoes and sandals. The objection there is nature of the goods. That basically looks like a flip-flop. That's the nature of the goods kind. You can't have a flip-flop shape for flip-flops. That's just ridiculous. The applicant pushes back against that argument by saying it's not just a flip-flop shape. All of the essential characteristics are not related to the nature of the goods. We've added a word mark here, and that's our word mark. We've also added some capricious design elements. So a little bit, a word mark plus a little bit. The word mark is just about visible here. If you have a look at it in the original trademark application. So it's not prohibited because we'll count the word mark as an essential characteristic. It's not related to the nature of the goods, so you're through. You don't get stuck by the prohibition. An agreement which seems to run directly counter to that is a previous decision by an OHIM Board of Appeals, which is now on appeal to the General Court. It has to do with the Clipper lighter, and Clipper's a fairly reputed lighter brand. The argument here is quite similar. Up there on the right-hand side, in one of the 5 depictions of the lighter, you have the word Clipper. The question is the word mark Clipper part of the essential characteristics of the overall shape? If so, it's not technical. Here it's a technical result kind of question, and they're saying the word mark has nothing to do with the technical result if it's part of the essential characteristics. You're home free. The Board of Appeals applies a few different ways to work around that shape mark. They ultimately reject the application. They say it is all about a technical result. They say the mark you've applied for is a 3D mark, so we're going to focus on the shape, and the shape is the main aspect of it we're going to analyze. The predominant and essential element of the protected subject matter is the shape. The word mark element may be considered de minimis, so we're free to ignore it. The word also only appears in one of the 5 views, so you didn't consider it important enough. Your written description could have indicated the word as part of the relevant representation, or you could have applied for the word as a position mark. And the word size is so small that the visually dominant element is the shape, and we'll count its essential characteristics instead. So there's some strategic game playing being done in terms of what you can add to something by way of a word mark to make it escape the gateway. So now let's turn to the substantive prohibitions and sort of work through them. Nature of the goods has recently been explored in quite interesting ways via the Hawke case, and people are still trying to work out the implications of this case. It could be potentially very radical, or there could be a way of trying to read it down and set it in quite a limited context. The question is very simple. When does a shape result from the nature of the goods? A prior approach, which I'm calling approach A here, which was adopted by the UK Court of Appeals in Phillips and was part of OHIM practice, was, well, a shape is essentially representing the nature of the goods when there is no design choice, when you're locked in. That's the only shape you can come up with. It doesn't have to only be natural shapes like bananas or pineapples or pears. It could also be shapes which are conventional or socially constructed shapes, but where, for a number of different reasons, there's only one way in which to possibly do it. So if our test is it results from the nature of the goods when there's only one possible way to do it, you can demonstrate a variety of alternative shapes to defeat this prohibition. Approach B was more generous in terms of giving the prohibition more teeth, and it said you're not permitted to register a shape consisting exclusively of the universally accepted features for the goods concerned. That's how the Advocate General puts it. So we're talking about generic shapes, not generic words like table for table, but generic shapes, if that makes sense. So an oblong shape for bricks, or a container with a spout and a handle and a cap for a kettle. Those would be sort of your generic features of your shape. So the Advocate General really elaborates on this. And again, I'm sure that you've been told this here, but the Advocate General opinions are really the more interesting ones to read quite often because of the reasoning that they contain. The narrow approach, it's the only way to do it, so demonstrating alternatives means we're past the hurdle. That approach was rejected. There's no indispensability or only shape requirement. The exclusion applies to shapes, all of whose essential characteristics result from the nature of the goods concerned and are therefore determined by the practical function which those goods perform. What you're trying to keep out is shapes consisting of little more than generic features. So if I ask you to imagine a bicycle or a chair, we'd probably have different ideas in our heads, but they'd probably have similar features. And that's what we're trying to get at, some kind of fuzzy, platonic ideal. The more interesting question may be the second order question. It says, why does a bicycle have generic features like handles and a saddle and sort of 2 wheels? Those generic features are functional. They serve a purpose. Not technical, which is the other limb, but functional in a low-level way. And that's the example the Advocate General gives with the flip-flops. And he says, therefore, that a user is likely to seek these features in the products of competitors. The problem which this provision is trying to address or redress is Acquired distinctiveness means you can take a fairly basic shape and through advertising just push it onto the trademark registry. And that might lead to a problem. So do we have another test for keeping fairly basic shapes out? Our first level test is, well, the shape is descriptive or generic or non-distinctive. You use acquired distinctiveness to get past that. Then do we need a second order test for saying, but this is such a basic shape that we need to keep it open? And that's what the Advocate General is trying to craft here with this provision. The problem, if you don't come up with this second order generic status test, is you can get through via acquired distinctiveness, and the infringement test means you've got a glass like this registered, you can go after glasses which are quite similar. So you start getting a wide number of glasses around you prevented from entering the market, and that's the concern here. This sort of concern is especially relevant for practical shapes where creative choices are limited. So presumably there's only so many different ways you can do a glass. Yep, you can do shot glasses and test tubes and a few different things, but basically it's got to have a way of containing the liquid in it. So creative choices are limited. However, where a shape has other essential features which do not directly result from the function, then it's registrable. So he gives the example of a differently shaped guitar. So think of the wildest death metal guitar you've ever sort of thought of, and that presumably doesn't get hit, but your generic clip art icon of a guitar would probably get hit by this, and that's presumably what he's trying to keep out here. And this approach is confirmed by the Court of Justice, which first says you can always save a shape by adding imaginative or decorative elements. So you can take your basic guitar and jazz it up, and then it's fine to be registered as a shape. Don't jazz it up too much because you get hit by the aesthetic prohibition. But if you jazz it up enough, or you jazz up elements of it, then you can sort of escape this "it's a basic shape" sort of prohibition. The provision clearly applies. This prohibition clearly applies to natural products and regulated products. There's a legal standard around the dimensions of a product, so every brick has to look pretty much the same if you want to use it in a certain kind of building industry. But it extends beyond this as well to essentially generic shapes. Generic shapes have certain features. You expect these features in every teapot or every bicycle. Why do you expect these features in every teapot or bicycle? Because they're functional. They perform a function, not in a technical way, but in a more low-level, practical, tables keep things up, chairs let us sit on them kind of way. And consumers may be looking for these in the products of competitors. So the case very clearly answers one initial debate, which had been ticking along for a while, but is gradually muted. It's very clear now the provision is not restricted to just natural goods. It also applies to conventional goods, not just regulated conventional products like specification limited footballs, but it extends to all kinds of products where there is a conventional or platonic shape template, which sort of makes intuitive sense, but is pretty difficult to apply. And you get a sense of how it's difficult to apply when you start thinking of the backdrop you're going to use for a comparison. So this sort of reasoning says you've got to avoid the generic teapot. That's what you're looking for. But how do we know we're looking for a generic teapot? What's the backdrop to use for the comparison? There are a couple of different approaches. Initially, these are arguments from some of the older cases. Remington, who was the defendant, the person challenging Phillips's trademark, said goods on which the mark was intended or actually used should form your template for judging what the shape mark is about. That was rejected, but in Phillips at the Chancery Division decision, Robin Jacob gave the decision there, he said, don't look at the trademark registration form, consider the goods as articles of commerce. So here the choices were three-headed rotary shavers, very specific, and if you had that as your target, then Phillips's three-headed rotary shaver would look very much like a baseline three-headed rotary shaver. It would be blocked by the nature of the goods. As you start expanding the nature of the goods outwards, it becomes less easy to say the shape results from the nature of the goods. So there's a difference between rotary shavers, which is broader, electric shavers, which come in even more shapes and sort of configurations, or shavers, which come the good old-fashioned sort of cutthroat razor and all kinds of things, in which case your shape doesn't map onto the nature of the goods that easily at all. So, and why Robin Jacob chose this level of resolution is, he said electric shavers are seen as a single type of commercial article, so I'll go with that as my baseline. And he said then again, sort of there may be a mismatch in terms of the nature of the goods. That approach was rejected. How are these goods seen as articles of commerce? And the Court of Appeals goes back to the trademark on the registration form and how it's applied. And you see that registration form approach continuing. And this is a very interesting recent case, which has again gone up on appeal to the Court of Justice. This is a General Court decision. Back again with Lego, the minifigs. Your heads are probably starting to hurt right now. If you want me to clarify any of this, just put your hands up, stop me at any point, and I'll sort of get back to where we are on the map of the presentation. The argument here is the shape results from the nature of the goods, that minifigure shape, and we therefore have to start by asking, well, what are the goods we're talking about? And the opponent, the person objecting to Lego's registration, who's Best Lock, who's a competitor in the toy interlocking toys market, says the nature of the goods here is about interlocking toys. That's the goods we're talking about. And here, this shape results from the nature of those goods because bits of the shape, we know these sort of holes in the feet of the Lego minifig and the holes underneath as well. They were designed to allow the Lego minifigs to click onto a base plate and stay there securely so that people could play with them. So they're saying aspects of the shape have been conditioned or determined because the nature of the goods is interlocking bricks. So it's a difficult argument to run. The Board of Appeals rejects it. It says, look, when we're talking about nature of the goods, the shape must be determined by the nature of the goods. The Board of Appeals decision precedes Hawke, so they're not applying the Hawke nature of the goods, generic goods sort of test. The Board of Appeals reasoning is the shape represented the product, a toy, human figure, or mannequin. It did not necessarily result from the goods, interlocking sort of block toys, since toys could be made in many forms. It makes sense, except they're drifting back to the reasoning of if there are different ways of doing it, it doesn't result from the nature of the goods. When the court said, no, that's not really the line of analysis we should be thinking of. The General Court is let off easy because it says, look, the opponent never really substantiated this argument. They never really told us why the shape results from the nature of the goods. You didn't do enough with the argument, so we'll let the Board of Appeals decision stand. But if you were to answer the question of whether this shape results from the nature of the goods, it starts opening up some of the difficulties with that kind of analysis. Is your template toys and games and playthings? Do you reject the nature of the goods argument because there are many different ways in which these can be represented? Or do you accept the argument because if you want to make a minifigure which looks like a human being, then that's pretty much, it has arms, legs, heads, a torso, and these are the generic features like a teacup would have, a teapot would have, a spout, a handle, a cap, and a container. So there may be something turning on this difference here. Technical result we turn to next. We know more or less the arguments here, so I'm going to skim through it. I'm going to skim through it quite quickly. Exclusively and necessary are the core requirements here. We know what exclusively was about. That's the essential characteristics analysis, and we know what they said about necessary. Phillips's argument again was necessary should mean it's the only shape to do that kind of work. Then we know it's necessary. If there are alternatives which exist, alternative shapes which can help you to shave, then that defeats the necessity argument. It was rejected by the court, and the court essentially said, is there a causal connection? Did you choose the shape to do certain kinds of work? If you did, then it's got a necessary connection. And on that basis, Phillips chose their three-headed razor shape to do the work of giving people a closer shave, and that satisfies the necessity requirement, and therefore it's a prohibited shape. Some more interesting questions have arisen since then. What about hybrid shapes? Phillips and Lego give us answers for shapes which are more like the key. They don't give us answers for shapes which are more like a novelty corkscrew, is the basic point I'm trying to make. Phillips and, so here's our spectrum. You can have shapes which are pretty much 90% or 100% technical. You can have shapes which are completely not technical, arbitrary, capricious, these kinds of shapes, which will then get hit probably by the substantial value sort of objection. And you've got shapes in between, part technical, but capricious design. How do we handle these kinds of shapes? Because the worry is still there for this part of the shape. We want to keep this open for everybody to use. But our test is directed towards these kinds of shapes. So just by being a hybrid shape, does it fall out of the test? Can it get onto the register? And can this part, by being on the register, create the same kinds of problems that that sort of test is designed to avoid? Does that make sense to you? You see the hybrid shapes sort of problem. So what about the in-betweens? Phillips and Lego Lego attempts to answer this question indirectly. The Advocate General addresses it directly. The Court of Justice, in a quick aside in paragraph 72, right at the tail end, it just throws out a potential solution. We know what the court said in Lego. You identify the essential features of the shape. All of the essential features of the shape have to be technical. So really they're talking about shapes only closer to that end of the spectrum. This would presumably be an essential characteristic or an essential feature, the moustache bit, no matter which way you ran the analysis. It's not technical, therefore you're not going to get stopped by the prohibition. You're not exclusively technical. How do we handle this kind of situation? The Advocate General explores a couple of options, including restricting what can be registered. So restrict your trademark claim via a disclaimer only to this bit and exclude any claim to the functional bit. So you say, I'm registering the whole thing, but I'm not claiming any exclusive rights over the technical bit. But there are a number of problems with disclaimers, including whether they have any legal effects in infringement situations. He says, if you don't want to go down that route of disclaimers, you can run a balancing analysis. Is there a competitive need to keep that shape considered as a whole open? But there are problems with defining product markets. You go down the US route of functionality here. When you're trying to look at a shape overall and see if we give this shape to one party, would that generate anti-competitive effects on the market? It's more case by case, it's more evidence-led, and it's fuzzy, but it's flexible. And we're not sure whether it's the right way to go about it. The Court of Justice seems to suggest that the answer to this question would be handled via infringement. So you let that into the trademark register, and then when you're running the infringement test, you say, we have to focus on the distinctive and dominant elements of a trademark. We will choose this to be the distinctive and dominant element, and we will ignore the technical elements which are common to two corkscrews as non-distinctive and non-dominant. It seems to be an artificial imposition on the way the test is normally run under the likelihood of confusion, but that's the way they seem to suggest that the problem should be handled at the infringement level and not at the registration level. So that's interesting, and that's very much a watch this space sort of development. The other issue I very quickly want to touch on is we know that Lego told us that a prior patent is one of the things you look at to see if a shape is necessary to achieve a technical result. How dispositive is the prior patent? How much should we rely on it, and sort of how much does it then dominate the agenda? There are some decisions by the Board of Appeals, including that for a hula hoop. I don't know if you can notice, but it's got a ridged sort of interior. And that is supposed to do a couple of things. It's supposed to be safer because it's contoured. It's supposed to grip the body better when you're gyrating. And it's an exercise hoop. So the overall function is core muscle strength building, something which I desperately need. And very young children like drinking beer. Bad combination. So the functional aspect is core strength. The grip helps to develop that core strength by making the hoop stay on longer. And so therefore, and the international patent is sort of designed to showcase the advantages of the technical advantages of that kind of design. They use the general gist of the patent to identify the essential features of the shape and knock it out. So they treat the patent very broadly and try and keep the shape out. The same shape has been accepted in the US as a trademark, and the functionality prohibition didn't operate there because the applicant was able to show that there are alternative choices, which is not the test in the EU, but that shape has gotten through in the US. The Lego minifig case, which is the slide I was desperately trying to finish, but I didn't sort of get to, has a much more narrow reading of the patent. So the General Court there says, there are prior patents for Lego minifigures. These patents are based on the design of the feet, which allow the minifigure to attach onto other Lego bits. You can make them sit in cars and helicopters. You can make them stand and pose them as if they're running because one foot clicks onto the base plate. And it's that better connection coupled with improved posability for toys, which is the basis of the patent. In the General Court decision in Lego, they say, okay, that's really just talking about what the legs do. So the patent applies to a part of it being technical, the rest of it is non-technical. So we limit what the patent is relevant for, and we don't let it dom. Just because there's a dry patent, it isn't a smoking gun. Last couple of slides, technical versus merely functional. This I thought was quite interesting. I'm sort of beginning to think it's an even more interesting question once you have Hawke talking about nature of the goods, generic goods. Why are they generic? Because parts of them are functional. We might want to come back to this distinction between technical and functional. Almost all shapes have a function. You are currently sitting on functional shapes, and I'm not being rude or personal. I'm talking about the chairs. They're sort of shapes which they're designed to support people. They sort of keep you up. So does that count for technical? Why isn't it technical? It's a way of asking, what do they mean by technical? They seem to have a specific sort of sense in mind. And here they seem to be implicitly borrowing a patent law approach which resonates with the underlying policy rationale of the prohibition to keep out patentable type shapes. When judging inventive step in patent law, you use the technical problem and technical solution approach. You start with the closest prior art. Then you look at whether the claimed invention proposes a solution to an objective technical problem. And if you read the Lego case all the way back down the appellate chain, you see this seems to be, especially the Grand Board of Appeals decision and the General Court decision, this is the understanding that they seem to come up with. And it's endorsed by the Court of Justice, which uses the language of technical solution, which seems to be taken from patent law. So we're really talking about patenty kind of things which are kept out by the technical solution provision. Last one, which I'm going to speak about, is substantial value. And really, one of the questions which goes up to the Court of Justice in Hawke is, what if the product appeals to the public in part because it's stylish, but in part also because it's a very good quality music speaker, as was the case in Bang & Olufsen, or because it's got a fantastic brand name associated with the product, as was the argument in the Benetton versus G-Star case as well. So products can have value for different reasons. Would it count for the purposes of the prohibition if substantial value was one of the reasons? And the simple answer the court gives here is yes. Some people have read the decision to say, is it telling us we also start needing to count other kinds of values as substantial value? Ergonomic value, comfort value, well-designed technology value. And if you read the decision closely, to me the answer is no. Really what they're saying is where it has mixed types of values, one of which is substantial, pretty aesthetic design type value. That means the prohibition still applies. As long as one of those values is design type, we'll keep the shape out. And that's what they're talking about here. The specific question asked in Hawke was, is the consumer perception dispositive? And the Hawke court said no, the Court of Justice said no. The presumed perception of the average consumer, why they buy it and do they think it's stylistic, matters. It's one of the criteria, but other criteria are also relevant. The nature of the category of goods concerned, the artistic value of the shape in question. So is it designed to be artistic? Is it recognized as artistic by experts or by design museums? Its dissimilarity from other shapes in common use on the market concerned, a substantial price difference in relation to similar products, which in part might be attributed to aesthetic reasons, the development of a promotion strategy which focuses on accentuating the aesthetic characteristics. So in short, sort of push factors, how it's sold and how it's projected by the owner, perception factors, how it's received by consumers, how it's received by experts, how it's received by the general public. So design museums and consumers would be relevant as your market share. Whether the industry itself recognizes it as a high quality design. These are the factors. The Bang & Olufsen case is a very good case. It's a general court decision and the Board of Appeals decision before that. You get to see these factors in practice. You're also starting to see courts applying these factors. So that should read subsequent application. So this is the case which you may have done already, the London Taxi Corporation, really about whether the shape of the London cabs can be registered. If you read the decision, it's pretty much a revision of everything you need to know about trademark law. It's a Richard Arnold decision. I probably don't need to say any more. He systematically worked through all of the ways of knocking these cabs out as shape marks. One of the reasons is the shapes which add substantial value. the London cab shape was registered as both a three-dimensional trademark and a UK design. So that knocked out the UK trademark essentially. It was also registered as a community trademark, and these factors knocked it out. They ran the Hawke criteria. Richard Arnold was very clear that the focus is on the shape itself and not on goodwill derived from sales and advertising. So we're not going to use your trademarky kind of value and count it against you. He was clear that shouldn't count. But then he runs through the factors in detail. He goes to consumer perception and he says consumers look, it's slightly ambiguous in terms of how he interprets this, but he says consumers place a value on the taxi cab as a shape. The category of goods, well, we're talking about cars. People do buy cars because of the shape of cars, and the aesthetic design of car shapes is a recognized phenomenon. Ferraris are designed in certain ways for a reason, and that's what's happening here. The artistic value, well, it's recognized, the cab shape is recognized as iconic, as a design classic. It's dissimilar in shape to other cars like saloons, so you know the dialer cab sort of equivalents. The price is similar to other specialized taxis, but very different from other ordinary saloons. And the promotion strategy emphasized their appearance. He goes with the underlying policy really here, which says, look, if you had design protection, then you're a design. You cannot bypass the limits to the life of that design by also going for a trademark. And he's very clear about his reason for keeping it out. You also see a more ambiguous application of Hawke in a recent OHIM Board of Appeals decision, where they're applying it to the famous Ames chair. And they run through the Hawke factors here, except they sort of mix up substantial value again with other values. So ergonomic value, comfort, the comfort of the chair, the fact that the chair is well designed and thoughtfully designed, they count all of that towards substantial value, rather paradoxically, and then they also run these Hawke substantial value factors. So courts are beginning to apply these factors, and we should see more and more design-type shapes being kept out of the system. The final topic, and literally just the last two slides, so thanks for staying with this. When you're asked to evaluate whether a shape mark is hit by any of the prohibitions, to what extent are you allowed to peer under the form? You have the form, there's the graphical representation on the form and a written description. To what extent are you restricted by that, or can you reach through to try and understand the reality behind the mark and say it's that reality we're trying to keep out from registration? It comes up in the Yoshida Metals case here. In this case, the applicant just submitted that as the representation. The court ultimately concluded that what those dots there represent is little holes, sort of concave holes on the surface of a knife, and we all know why we have concave holes on the surface of a knife, and it's for a better grip. How did they know that? They looked into the marketing literature, they looked into prior patents, they looked into other stuff to try and make sense of the graphical representation and the paper-based application. So are you allowed to look elsewhere and not just the application form to make sense of what's being applied for? They could look elsewhere based on the Lego leeway. Lego says when you're identifying the essential characteristics, you can look at pretty much anything. You can look at surveys, you can look at prior patents, you can look at expert opinion, and all of that will give you real-world context about what this product is and what the mark is supposed to be about. So you can consider all of this when you're trying to fix what the sign is they're talking about. So that said, yes, you can read between the lines. And this case said, no, you can't. And this one is up on appeal as well, and I'm hoping they raise Yoshida Metals. This case doesn't refer to Yoshida Metals, even though it was decided before this case was decided. You can see the argument very easily here. These guys applied for that as a trademark. Their argument was you cannot see the interlocking mechanisms inside the skeleton from the surface of what we've submitted. At best, you can see the lines here which suggest shadows and some depth, but it's a cage. You have no idea what's in there. And all we want you to look at is the surface of the cage. You're not allowed to speculate as to what's inside. And the court agreed with that argument. They said we cannot read into the black lines the hidden rotating capacity, or for separating the tube into layers. The real objection of the opponent in this case, Simba Toys, or Seven Towns, was based on prior knowledge of the rotating ability, which is not evident from the application. The community trademark is therefore valid, no reference to Yoshida. So can you read into the application in order to see if the prohibitions apply. So that's plenty. That's too much, probably. Let's call time here. I'm happy to take questions.